Just want to go ahead and say good morning to everybody who's already joined us and say that we will get started in a few more minutes as we let people trickle in. Okay, good morning and welcome to the third session in KY Policy's 2021 conference, Reforming Sentencing Policy in Kentucky. My name is Carmen Mitchell and I am the Criminal Justice Policy Analyst for KY Policy, and I will be the moderator during today's fantastic discussion. And as a reminder, next week will be our final conversation, Economic Security in the Age of COVID-19, and that will be next Friday at January 29th. And you don't want to miss that. So go to kypolicy.org/registration to sign up today. Also, just to note, we will be utilizing the Q&A feature today, and we absolutely welcome questions. So please feel free to submit a question anytime during the program, during the Q&A feature, through the Q&A feature. And if you're watching on Facebook Live and would like to join us via the webinar, on the actual webinar, the link is in the Facebook event page. So why are we talking about sentencing reform for today's panel? So as I imagine everyone who's listening in knows, mass incarceration is a major problem in the United States, including in Kentucky, which has the 7th highest rate of incarceration among all states. Kentucky currently has nearly 20,000 people currently being held in our county jails and nearly 10,000 more additional people being held in state prisons. So to put that in perspective, if the incarcerated population in Kentucky was its own city, it would be the 12th largest city in the state, larger than Radcliffe, Paducah, Frankfort, Independence, and Henderson. So there's a strong consensus among many constituencies, political parties, and advocacy groups that we need to address the issue of incarceration through policy reform for many reasons. So we know many people are incarcerated either directly or indirectly because of issues related to social determinants of health, like poverty and housing instability. And we also know incarceration itself is a cause of many harms to individuals, including mental health, chronic financial hardship, and substance use disorder. And speaking of which, most people who are incarcerated are there for reasons related to drug use alone. And we've also seen, especially since 2020, that incarceration is a major public health issue, as it has been a vector in Kentucky and across the country for COVID-19 outbreaks. So as of this week, there have been 6,599 known positive cases of COVID-19 in DOC, Department of Corrections, prisons in the state. And there have also been numerous outbreaks across county jails last year, which made jails and prisons some of the top institutions for spreading COVID-19 in communities across the Commonwealth. So the bottom line is, if we don't address mass incarceration, we will not have healthy communities in Kentucky. And I would be remiss not to mention also during this time that incarceration is very much a racial justice issue as well, with Black Kentuckians being well overrepresented among the incarcerated population. So as of December of 2020, Black people made up 8.5% of the state's population, but represented 22% of the prison population. And mass incarceration is also a gender justice issue. So the number of women in jails has risen significantly over the past few decades, from 83 women in 1970 to over 3,700 in 2015, representing a 44-fold increase of women who are incarcerated. And as of November of last year, Kentucky was ranked the third highest state for rate of women being in prison. So that's the context, some of the context, not all of it, for why this is such a major problem. And something else is that due to COVID-19, we actually saw a significant release of many people who were incarcerated in Kentucky last year through expanded administrative release of people who were incarcerated and incarcerated pretrial and commutations of sentences from the governor. And it turns out the sky did not fall out on public safety. And everything was fine. So we want to continue to build on that momentum going into 2021 and beyond. However, despite the consensus we've had for a long time about the need to address this issue, and even after seeing the releases last year with minimal rearrests, we still have a long way to go to address the mass incarceration problem in Kentucky. And a key part of addressing this issue will involve making changes to Kentucky's sentencing policies. Unfortunately, in recent years in Kentucky, we've seen policies enacted that have increased criminal penalties and created new crimes instead of making significant needed changes in the other direction. However, momentum is emerging around policies that would make meaningful changes related to sentencing. So that brings us to the conversation we will be having today. So during today's webinar, our four fabulous guests, who I'm really excited to hear from, will be discussing key issues in sentencing policy nationally and at the state level, including those specific to the 2021 Kentucky General Assembly. So I am gonna stop talking now and throw it over to our first fabulous guest. And our first panelist speaking today is Nicole Porter. Nicole, if you would wave to the audience for those who are in gallery view. Nicole is the Director of Advocacy at the Sentencing Project, who will be giving us an overview nationally of sentencing reform. I will turn it over to her.
Thank you so much, Carmen. I appreciate being invited to present and participate today. And I've joined you all before when it was possible to meet in person. And I've always enjoyed traveling to Kentucky and meeting with the folks in your organization and also who come to your policy conference. It's always a great learning event for me as well. So I was invited to provide comments that offer a national overview and also offer some specific examples on sentencing reforms that have been adopted in recent years and that have helped to decrease other states' prison populations. So in recent years, there has been some modest reforms in Kentucky, as in many that you already highlighted, Carmen. And those changes have contributed to a modest decline in the state's prison population since it peaked in 2016. In fact, when the last national reports came out from the Bureau of Justice Statistics, Kentucky's prison population had a modest decrease of about 1%. But by comparison to other states, that is incredibly modest, although there were some states that had increases, states like Alabama, Alaska. But during that same period that the Sentencing Project looked at, there are a number of states that registered double-digit decreases in their state prison population since they peaked. So states like New Jersey, New York, but also southern states like South Carolina and other moderate states, including Vermont, which has a libertarian streak to it, registered 30% declines since their prison populations peaked through a mix of change in policy and practice. And as you highlighted, Carmen, there was no doubt a decline last year that you all are probably closer to, and I'm going to be looking forward to national reports that provide a broader picture on that. But Governor Beshear alone, when he signed that executive order, several thousand people, several hundred people were released in Kentucky. Other changes in other jurisdictions resulted in the release of several thousand people in states like New Jersey, California, New York, and I'll get into that a little bit later. Other practices probably contributed to declines last year, and you already highlighted some of them in your comments, Carmen, but commutation and early release mechanisms through executive order. Several states around the country did that last year, not just the states I've already mentioned, but also Illinois and Iowa also undertook similar changes that resulted in declines in their prison population in the context of COVID. I think one of the challenges of this window that we're operating in right now is how to sustain any practice changes that resulted in prison population decline, to understand what the outcomes of those might be, and then to operationalize them so that they can continue to drive prison policy and sentencing policy going forward. I'll say that even given the pace of decline last year and given the pace of decline in our analysis since states peaked, the level of decline is incredibly modest overall. In fact, it would still take about 75 years, even if things continued as they are, to return states and the nation to the levels of incarceration that we experienced in the early 1980s. So it is encouraging to hear about reforms that are happening right now, and even in the midst of this pandemic, but they are very modest compared to the muscular changes that happened in the 70s and 80s that contributed to mass incarceration. As you all know, and as Carmen highlighted already, the United States has the world's highest rate of incarceration for several reasons. There are two key ones. One, we send people to prison for reasons they don't go to prison for in other parts of the world. And when we do send people to prison, we send them to prison for longer. I've said this before. I think I said this when I met with you all a couple of years ago, that fundamentally this is a political problem where strategies must be employed to counter the current punitiveness that results in those high levels of incarceration. Countries and within the United States, states have the policies and prison populations that they choose. Between 1965 and 1990, during which overall and violent crime rates tripled in Germany, Finland, and the United States, German politicians chose to hold their imprisonment rate flat. Finnish politicians chose to radically reduce theirs, and American politicians enacted policies intended to increase the use of imprisonment substantially. All American states with the experienced large crime rate increases in the 1970s through the early 1990s, but their responses varied. Politicians in states like Maine, Vermont, and Minnesota, by and large, resisted the calls for enactment of the harshest laws that led to increases in their state prison population, although they did expand community supervision populations, so we can get into why those are problematic as well. But by comparison, politicians in states like Texas, California, Oklahoma, Florida, so these are states with varying degrees of political frameworks responded with enthusiasm to the increase in crime rates and dramatically expanded the number of prison beds in those states. So since the early 80s, the likelihood that US residents come in contact with the police has increased. This is a key driver for the number of people in prison. Once that person interacts with the police, their likelihood of being arrested has increased and their likelihood of going to prison has increased. That's a finding from the well-regarded National Academies of Sciences in a 2014 seminal study that really clarified what are the key drivers in imprisonment and the growth of incarceration in the United States. Now, that framework that I just provided an overview for, that since the early 80s, people have had a higher chance of coming in contact with the police. Once they come in contact with the police, they have a higher chance of getting arrested. Once they get arrested, they have a higher chance of going to prison. That's due to a range of policies that could be reformed, could be scaled back in a state like Kentucky, particularly if there's intentional work to downsize the state's prison population. There are a range of underlying issues, underlying practices that contribute to that increase in arrest and that increase in imprisonment. Policies like the expansion of life sentences, the adoption of habitual offender statutes that require mandatory prison time served, even for people who have prior criminal histories, regardless of the circumstances of those histories. So if somebody is using drugs and hasn't come out on the other side of it and able to manage their drug addiction, and they come up and they get arrested and have a subsequent term of imprisonment, the judge's hands are often tied and they're not able to mitigate against that mandatory time served requirement. And then other policies don't just include the expansion of mandatory minimums over the last 30 years, but also have lengthened the time served once someone is incarcerated. And that's contributed to why the US has that high rate of incarceration. Because remember, I said there are two reasons why, in addition to the increased contact with policing. There's the fact that we send people to prison in the US for things they just don't go to prison for in other parts of the world. And when we do send them to prison, we send them to prison for longer. So other policies include the abolition of parole. Once people get into prison, it's very hard for them to get out. And that's contributed to those lengthy terms of confinement, also helping to drive up this Kentucky's prison population and the nation's prison population as well. In fact, Kentucky's life sentence population is 53% higher than the state's total prison population in 1970. The number of people sentenced to life only is 53% higher than the state's total prison population in 1970. And that outcome tracks with a number of other states around the country as well, including the state's national prison population, which the number of people serving life sentences today is higher nationally than the total number of people who were in prison at the federal and state level in 1970. In many ways, it's not just the policies themselves, including those habitual offender statute, mandatory time served requirements, and the abolition of parole that contributes to this punitiveness and these lengthy time served requirements, but it's also the responses to very serious offenses and how the United States compares to other industrialized nations. Let's take burglary, for example. The time served in the United States is on average 15.2 months longer than that in other Western nations that many people in the United States share a common ancestry with, including that of Scotland, where the average time served for burglary is 4.1 months, and that of Sweden, where the average time served is 6.4 months. Similarly, for robbery in the United States, the average time served is 37 months, and that is substantially longer than the time served also in Scotland at 10.9 months and in the Netherlands at 12.5 months. Now, Carmen mentioned racial disparity and how those outcomes play out in Kentucky. So the statistics that I just provided an overview of mask the racial injustice that is embedded in the system and has a disproportionate impact on Black residents in particular. Because everyone since the early 80s is more likely to come in contact with police and more likely to get arrested, African Americans are more likely than white residents to be arrested because they live in communities that are over-policed and have a higher police presence. And once arrested, they are more likely to be convicted. Once convicted, more likely to experience longer prison terms. As of 2001, nationally, 1 of every 3 Black boys born in that year could expect to go to prison at some point in their lifetime. The underlying causes of these disparities are what I just provided an overview for, that high rate of police presence in mostly Black communities that are in central cities around the country. And, persons of color and those who are both of color and poor experience a much different criminal justice system than those who are wealthy. Wealthy defendants can buy effective legal representation that ensures that their constitutional protections are guaranteed as defendants. Yet the experience of defendants of color who are poor might be substantially different from that model. And then a number of factors that accumulate as poor defendants of color go through the criminal legal system build, contributing to those disparities, not just at the point of arrest, but also at the point of sentencing. So there are underlying social policies that contribute to these structural inequalities that can't be addressed purely through sentencing reform. But I do think in working to reduce the number of people in prison might free up public resources that can help address some of the social policies that would not just help reduce the number of people that come in contact with the criminal legal system and the scope of the number of people in prison, but also help to undo the structural inequities that result in high rates of racial disparity in the state's prison system, not just in Kentucky, but this could also contribute to national changes in how the criminal legal system treats residents of color in particular when coming in contact with law enforcement. It's just so important to remember that behind each statistic are people, those who are directly impacted by the reality of race on the criminal legal system in the United States. Behind each percentage point of the 60% of persons nationally who are behind bars as people of color include a Black man who might have been disappeared behind the walls. Behind each number is a young Latina girl who will spend a few years visiting her parents in prison waiting rooms. And behind each data set for a research organization like the Sentencing Project is a community, a neighborhood that has a high rate of incarceration. So to address that, there are reforms that I want to highlight as I wrap up my comments that can help address and contribute to downsizing the state's prison population. I mentioned earlier that there were several states that had a 30% reduction since their prison populations peaked. Those states include New Jersey, that scaled back their state's drug sentencing or sentencing enhancement zones that resulted in lengthier time served requirements for people with prior drug use disorders at their third or fourth sentencing for a drug offense. And all 50 states in the District of Columbia have sentencing enhancement zones. Last year, several states enacted sentencing reforms in the midst of the pandemic, including New Jersey. I'm going to go back there. They are a state that has had several reforms in recent years. I mentioned earlier that over 2,000 persons were released under a law change to move up people's release dates. Last year, too, the DC City Council enacted what is known as a second look policy, giving persons under age 25 who served 15 years in prison a pathway to court. These are persons without any exclusion, so it also includes violent offenses, to be evaluated by a judge for sentence modification. And then last year, the state of Virginia also expanded parole reviews to include what we call old law prisoners. These are persons sentenced prior to the state's current mandatory minimum sentencing requirement. Most of those individuals are now eligible for a review, and this year they may build on that reform because the state's crime commission is recommending the end of mandatory minimum sentencing and restoring judicial discretion in individual sentencing requirements. So these changes are encouraging. There's a lot more work to do because, as I mentioned earlier, in spite of these changes, they're very modest, and it would take many years to get back to the incarceration levels of the early 80s. So I'll stop there. I look forward to hearing the comments from the other panelists and also answering any questions. And thank you, Carmen, and everyone for inviting me to present this morning.
Thank you so much, Nicole, for that really great overview. I just have one question I'm going to go ahead and ask you real quick since we're doing pretty good on time. We got a question from the audience that said, what are the behaviors that we send people to prison for in the US that other countries do not?
Well, I think it's not about behavior because Americans don't act any different than people in Sweden and Germany or Finland. We do send people to prison for things they wouldn't get sent to prison for. That's not about behavior. That's about the punitiveness of the system. So I think one of the key drivers of that is what I mentioned. There's a high rate of policing in the United States that contributes to common, regular residents regularly interacting with law enforcement. And because of the nature of policing, those interactions often end in arrest and subsequent criminal conviction. Now, the criminalization of certain activity and what's also been clear is that even law enforcement misunderstand the law, but once there's an interaction that happens, there's a range of activity in that interaction that can result in someone's criminal conviction in ultimate sentence, whether or not it's in prison or in the local jail. You can take Ferguson as an example. That the Ferguson report documented that police came in contact with residents in a range of ways, people sitting in their cars that they owned. And it was the nature of over-policing that led to very adversarial outcomes that might have saddled someone with a criminal record, even though the initial reason for the stop was rooted in racial bias, was discriminatory, and unfair. And yet the system validated and legitimized that stop in what transpired afterwards. So we could go into many anecdotal stories from Ferguson, and probably right in Kentucky. I think a Ferguson report should be done in every state. And, I'm sure that there's a lot to learn in Kentucky around similar experiences. Then I'll just wrap up by saying that once someone is convicted of a crime, and if they're subjected to probation or parole, the interactions with law enforcement can highly increase their likelihood of going back.
Am I frozen or is it? I think Nicole froze up. I don't know if she can hear me or not. Oh, we will go ahead. We'll wait for her to come back, but as we know, Zoom has freezing issues, so we'll go ahead and keep going, and I will introduce our second panelist, Damon Preston. And Damon, if you could come off camera and give us a wave. Damon is Kentucky's public advocate who leads Kentucky's Department of Public Advocacy. And I am president of the Damon Preston fan club, so I'm really excited to hear from him. And he will be talking about Kentucky specific problems and solutions in sentencing reform.
Thank you, Carmen. It's great to be here this morning. I'm a huge fan of the Center for Economic Policy, the work. I have a degree in math. I love data, and so this group really plucks my strings, I guess is one way to say it, with the work of the Economic Policy group. I want to talk about Kentucky specific problems, kind of how we got where we are, and then also a little bit of what we recommend as solutions moving forward to address over-incarceration and over involvement with the criminal justice system, even for people that don't wind up in jail. There are too many people being supervised and that come into contact with the criminal justice system. So we want to offer some solutions for that. I want to start by just talking about how we got to where we are. An old saying that I've heard many times in different contexts is, if you find yourself in a hole, first thing you should do is stop digging. And I think when it comes to state criminal law in Kentucky, we haven't gotten that lesson yet, because over the past few years, well, not just the past few years, over the past 30 years, Kentucky has passed a lot more laws to make matters worse than we have to make matters better. I've been involved in criminal justice reform discussions now for over a decade. House Bill 463 was passed in 2011, but itself was the product of discussion that went back to 2007, 2008, and then finally led in 2011 to passage. So at least 13 years of talking about criminal justice reform. But while we have these lengthy discussions and task force and committees talking about reform, we're actually just passing laws quickly that make matters worse. So one thing, a hobby I've done that over the past few years is just at the end of each session, I count up how many bills passed that either increased sentences, expanded crimes, or created new crimes, those three things. And then I also look at how many bills passed that either eliminated crimes, narrowed elements, or reduced sentences. And here's the scorecard for the past 3 years. In 2018, 26 bills passed that that aggravated the situation, created new crimes, expanded elements, or lengthened sentences. 26. How many bills passed that did anything in the opposite direction, even if it was very minor? How many did something in the other direction? 2. 26 to 2 in 2018. 2019, the number that aggravated the situation went up to 31. Fortunately, the number that mitigated went up. It tripled to 6, 31 to 6. And last year, in a COVID shortened session, where not as many bills passed overall, it was still a ratio of 3 to 1. 9 bills passed aggravating the situation, 3 bills passed making things a little better. And those bills that made things better, I do want to emphasize, there have been no major reform bills in the last 3 years. The Dignity for Women Act that passed, I believe that was 2019. That was certainly helpful legislation. But for those of us that worked on it, there was so much more that was talked about being in that bill. And at one point, I don't want to say everything good, but over half of what I would have considered the good things in the bill were stripped out so that it could pass so that parts of it could pass without objection. So we've continued digging, making things worse. And in some of the bills that passed that have helped things are very small. And I wanted to give an example this morning. 2019, there was a bill that passed that narrowed the crimes against being an unauthorized sports agent. I know that's a case I've handled a lot as a public defender. I've had a lot of my clients that were charged with illegal sports agent activities. But one of the other ones, there was a bill that passed in 2019 that had this great language in it. Doesn't this sound exactly like what we need? Whereas individuals may find themselves subject to needless prosecution, an emergency is declared to exist. This bill had an emergency clause in it because it was so important to eliminate needless prosecution. And what was that needless prosecution? Here's the language that is in the middle of this clause. The inability to possess, consume, or provide alcoholic beverages at a private residence or a private event is a hindrance to individual freedoms and commerce. And therefore, we have to fix this. It was bootlegging. The bootlegging statute in Kentucky was narrowed because middle-class families were not able to hold public events in dry counties and serve alcohol without technically running afoul of the Kentucky bootlegging law. So when there's a need to change laws, the criminal law, to narrow it, it can be done. And it can be done with an emergency clause that became effective immediately. So this process can be done. We just don't have the will right now to do it. And so we continue digging deeper. One example of a bill that aggravated the situation was in 2019. And it was the Strangulation Bill. And I'm sure some of the people watching this may have been in support of that. Many of us may be concerned about domestic violence and about the effect of legitimate strangulation issues in that context. But the bill that passed is an example of how Kentucky is quick to pass things that make matters worse without any balance on the other side. The Strangulation Bill made it a felony, and in fact, the final version created 2 degrees of felony, a Class C and a Class D version, and crimes that have previously been prosecuted as misdemeanor assault fourth suddenly became strangulation prosecutions, Class C's or Class D felonies, and so immediately what had been a misdemeanor became a felony. But now let's look 2 years later at what has happened in the strangulation case. So I ran the numbers this morning. In calendar year 2020, there were about 1,500 cases in district and circuit court in which strangulation was charged around the state. 1,010 of those were in district court, 488, less than half were in circuit court. So if you're not familiar with the mechanics of the system, typically cases start in district court and then go to circuit. So what it means when I look at the numbers and it shows twice as many district courts as circuit court cases, what that means is half the cases were worked out at the district court level. That means that this bill was passed to make it a felony, but half of the offenses that have been charged with this have been worked out at district court anyway. But the effect of that is that the prosecution had the leverage of this Class C or Class D felony, and so the resulting plea agreement likely involved actual jail time, probably 30 days, 60 days, 6 months, perhaps 12 months in jail at county expense, raising our county expenses and packing our jails because of this leverage that was filling a gap that really, if there was a gap, it was an extremely narrow gap, but this broad bill passed to create more imprisonment and more incarceration. Another impact of the Strangulation Bill is the impact on racial inequality in prosecutions. I looked statewide, the racial breakdown of people prosecuted with the felony strangulation, 67% have been white, 31% black. Sounds what? Majority white. Well, you should know that DPA does not cover, my agency does not cover Jefferson County. If you exclude the population in Jefferson County, the percentage that is white or that is African American in Kentucky is 8%. If you exclude Jefferson County, take the other 119 counties, the census says it's 8%, and 31% charged with strangulation statewide, not including Jefferson County, are African American. If you look at the county that prosecutes strangulation the most, which is Fayette County has 9% of our overall caseload, excluding Jefferson County, but they have 21% of the strangulation cases, twice the level that they should proportionally, because they're really pushing strangulation. And the racial breakdown in Fayette County, 60% African American and 38% white being prosecuted. So the effect is we created this new felony, which created new leverage that will result in new prison time and new jail time, and it is being applied in a way that is that appears to be looking at data only. Who knows what the underlying reason for it is, but looking at data only appears to be applied in a way that is unequal and disparate. So the Strangulation Bill is a case study of kind of how we got in this bad situation, because we just passed laws and then they're applied in ways that may not be as intended. Sometimes it may be exactly as intended, but it's not in a direction that will make the system more fair and more reasonable and reduce incarceration. So beyond that strangulation, let me talk about some other things. Kentucky's got a broad mandatory minimum habitual offender, I think is the phrase that Nicole used, called PFO. Marcus is going to talk about that in a few minutes, but that has played a big impact on the criminal justice system, and any solution, in my opinion, that's going to significantly address the prison population in Kentucky has to address the PFO statute. There's also a effect of the war on drugs. It's well known that that's a driver in the prison population. Kentucky is, I haven't run the numbers. I don't know if we're in the majority or minority, but Kentucky has no such thing as misdemeanor drug possession when it comes to the headliner drugs, cocaine, meth, heroin, LSD, those things. There is no such thing as misdemeanor possession of those. So if you possess those drugs and are arrested, you will be charged with a felony. You may be offered diversion, which still involves a guilty plea to a felony, but you may not be offered diversion. And plenty of people end up actually going to prison for drug possession, even if they get probated. If they're addicted to drugs, you can't beat that overnight. Some people never beat it, and they could end up violating probation and going to prison. This happens a lot. And making matters worse, in some areas, the maximum sentence is probated, as prosecutors and judges refer to that as a hammer. They want a bigger hammer to incentivize obeying the conditions of probation. Well, often that hammer ends up actually falling, and people go to prison for extended periods of time simply for drug addiction. And that drives it. Beyond possession crimes, there are also other felonies that are often charged. In 2011, when possession was reduced from a maximum 5-year sentence to a maximum 3-year sentence, one thing we saw was all of a sudden, almost every drug possession case also had a tampering with physical evidence case, because tampering with physical evidence is a Class D felony with a maximum of 5 years. Prosecutors and law enforcement saw that they could maintain the leverage despite reducing the crime of possession. They could maintain the same level of leverage by just charging the Class D felony of tampering. Because if you possess illegal drugs, what are the chances that when a police officer approaches you, that you say, "Oh, I'm sorry, officer, here are my illegal drugs"? No, you're going to try to hide it. You're going to try to get rid of them. You're going to try to run. You're going to do something. And that something, under the broad tampering law in Kentucky, can qualify as tampering. So we saw an increase in tampering because the offense of drug possession was reduced. So reform has to take into account charging decisions, and it has to be a comprehensive reform. There are many instances like that where there are overlapping crimes, where a person can be charged with drug possession, tampering, fleeing if they ran, or multiple counts of any of those offenses. Comprehensive sentencing reform needs to involve limits on consecutive sentences, limits on overlapping charges, and prosecutorial discretion. We have to define crimes specifically so that people can only be charged with a single crime, and across the board, all prosecutors, all law enforcement are charging the same thing, because there's a lot of disparity if you go from county to county on what people are charged with. And of course, as we talk about the drug possession situation, we advocate of having at least a misdemeanor version for first, second offense, maybe all offenses if they're not aggravated by some other more serious crime. But one of the complications with misdemeanor drug possession is then, as many of you know, if someone's serving time for a misdemeanor in Kentucky, that is at county expense as opposed to state expense, and then you've got a battle over who's paying for it. And we're going to talk about that more as this goes on. So I think one of the big issues that, as my final point, one of our solutions that we're proposing, we're calling a jury empowerment bill. And this will go, if it passed in the way we would like it to pass, this would help sentencing throughout in Kentucky. And what the jury empowerment bill says in general is the jury should have the option of saying that sentence is too high for what we just convicted this person of. And so a jury, once they learn about the defendant, the accused, everything about that person, including criminal history, good and bad, and then everything about the offense, they can take all that into account and say, we are choosing to give a sentence that's less than the law allows here. The law says 5 to 10. We think this should be less. That's what jury empowerment's about, and that will accomplish true criminal justice reform, because in the discussions of reform, prosecutors, law enforcement, they're elected or appointed for a reason, and they interpret that reason often to be tough on crime, to be pursuing maximum sentences, trying to put people in jail. And the jury is the real spokesperson for a community, and the jury should have the ability to say, I don't want to send this person to prison. I don't want to saddle this person with a felony conviction. Yes, he possessed that drug, but I am choosing to sentence to a misdemeanor or to sentence to a lesser amount. So that would make a huge difference, not just by giving the jury the opportunity to make this statement, but also it would help the defense attorneys and the accused to have a little bit of leverage, that we could require a case to go to trial instead of entering a guilty plea, because right now, in many cases, the prosecutor has so much leverage, the defendant pleads guilty whether or not he's guilty, because the stakes of going to trial are just too high. This would help level the playing field. So those are some suggestions. I'd be happy to answer questions now or later on. And I thank again the Kentucky Center for Economic Policy for inviting me. And Carmen, thank you for your time today.
Thank you so much, Jamin. And before we move on, I just want to clarify just real quickly. We mentioned the strangulation bill, and just to be clear, like, why is it a problem to have a strangulation specific bill? For those who hear it and say, well, I'm against strangulation, shouldn't we have?
Right, and as criminal defense, we find ourselves in the position a lot to be. It would be easy for us to be cast as pro strangulation, and we're not pro strangulation. Just to be clear, the problem with the strangulation bill is it was written very broadly, and basically, if you and I are in a altercation of any sort, what I could do to a person that would qualify under that bill is very broad. And so while serious strangulation cases should absolutely be prosecuted as felony, they already can be, because under assault second or crimes as exist. And so what the strangulation bill as it passed did was it didn't do anything to the actual serious strangulation cases, because they could already be prosecuted. All it did was make it a lot broader to bring in these activities that should be misdemeanors, but now they qualify as felonies. So it's a lot in politics and in legislation goes to labeling. There are labels. By calling this a strangulation bill, who in the right mind could oppose a strangulation bill? But that's the problem, is it defined the term so broadly, it brings in a lot of activities that really shouldn't be felonies.
Gotcha. Thank you so much. That was a really good explanation. So with that, I will turn it over to our third panelist, Marcus Jackson. Marcus is a superstar organizing coordinator with the ACLU of Kentucky, and he is going to be talking about Kentucky's persistent felony offender law, which was just mentioned previously, I think by Jamin, from the perspective of a directly impacted person. So Marcus, I will ask you to give a wave and come off camera. I think Marcus has the best background, so I will turn it over to him.
Thank you, Carmen. Thank you for having me on this panel. First and foremost, I would ask everyone to please bear with me. I am not a lawyer. My knowledge of Kentucky's persistent felony offender statute, or PFO as you will hear me refer to it as, is through lived experience. Countless hours and over decades served fighting the draconian law with very little success. I witnessed this law morph into Kentucky's greatest weapon to secure convictions, avoid trials, and increase the inmate population, as well as probation and parole caseloads. Just for a little context of where I'm going, prior to 1974's adoption of the Kentucky Penal Codes, Kentucky's criminal statutes operate under the belief that sentences should be no more than the offender deserved. They didn't prohibit probation, and they utilized incarceration as a last resort and means for rehabilitation. The Kentucky penal codes, for the most part, continue this belief, as reflected in the original PFO statute language, as only after the second period of actual incarceration and upon the third conviction would offenders receive PFO enhancements. The law took effect in 1974, and by 1980, the statute was utilized as intended, and it resulted in less than 100 offenders under the PFO statute. So without going too deep in the weeds here, the current statute defines a persistent felony offender in the second degree as a person more than 21 years of age who stands convicted of a felony after convicted of one previous felony, and for second degree after being convicted of two previous felonies or one or more sexual crimes against a minor. Under both of the offenses, the offender must be over the age of 18, on probation or parole, or within 5 years of completion of sentence, probation or parole. Offenders not eligible for probation, short probation, conditional discharge. And the thing about that is, if you are a Class D felony, if all of your convictions are for Class D felonies under that current one, you could be eligible for probation, conditional discharge, or short probation, which is actually a step in the right direction. But as far as regular sentencing, a Class D felony underlying offense, your level will be increased from a Class C range of 1 to 5 to 5 to 10. And if you're convicted of a Class C felony, which is normally 5 to 10, it will be increased to 10 to 20. And there are no parole restrictions based off of that. You will still be eligible for parole with the 15% for Class D felonies and 20% of that sentence. When it comes to first degree PFO is when things get really tricky. If you have a Class C or D felony offense, underlying offense rather, you are sentenced within a penalty range of 10 to 20 years. And if you have A or B felony underlying offense, you are sentenced between 20 to 50 years, life, or life without the possibility of parole for 25 years for any underlying sex crime against a minor. The statute for Class A, B, and C underlying offenses require you to serve 10 years before parole eligibility or is designated by other statutes. So, unlike the original statutes, the current version no longer contains the period of incarceration requirements. Restrictions have been placed on probation and parole. The number of convictions have been reduced from 3 to 2. All of these changes have resulted in longer sentencing. And according to a 2020 incarceration numbers, there were 2,174 of the 3,300 offenders incarcerated under the PFO statutes that are low-level, non-violent offenders that pose little or no threat to the public. So in my humble opinion, PFO is nothing more than a bully law that deprives judges of the discretion needed to administer justice and places that discretion in the hands of prosecutors. Oftentimes, defendants are forced to accept pleas and waive their constitutional rights to trial to reduce sentence exposure, as Damon touched on earlier. When it comes to legislation regarding the PFO statute, it has yet to be introduced, but we are expecting it. And Damon touched on that a little bit also with the jury empowerment. I support jury empowerment. However, the statute needs further revisions. The ACLU of Kentucky Smart Justice Advocates have drafted some revisions around statutes. We believe the 5-year requirement should be removed because once a sentence is completed, that sentence should be used to enhance anything further. We believe nonviolent offenders should not have to serve 10 years before parole eligibility. And we believe the elimination of second-degree PFO altogether and require 2 prior periods of actual incarceration should be required for your actual first-degree PFO. We also believe in increasing the age range from 21 to 24 instead of the 18 and the 21. And finally, removing all Class D felonies that do not involve physical action against a person or sex crime from counting as PFO eligible offenses. This law is very, very important to me. Personally, I have been impacted by this law. Seeing it on paper, reading it on paper and hearing the effects, it's so much different than the actual impact of this law. If you can imagine a 19-year-old kid with a simple possession charge of methamphetamine receives 3-year sentence, suspended for 5 years probation. He completes the whole 5 years probationary period with flying colors, no trouble. 4 years down the road, he has an incident with, just say, his girlfriend, where he happens to take her phone, her brand new iPhone, and leave the apartment. Out of anger, she calls the police. He's arrested. He is charged with a felony, and the prosecutor comes in and tells him that he's PFO eligible now. That simple incident that happens all too often, that in my neighborhood, we've definitely considered that a lower level offense. He would be looking at a sentence of 5 to 10 years for disagreement of taking a phone and leaving the house. Some of these laws that we are faced with daily are truly, truly barbaric. While I was incarcerated, I actually served a mandatory 10-year sentence for possession of amount of marijuana that caused it to be trafficking, putting it at a Class C felony. The PFO law required me to do 10 years flat before I was eligible for release. And outside of just the sentence itself, the way that the individuals are forced to serve the sentences. As a nonviolent offender, there is no way that any nonviolent offender should end up at a maximum security penitentiary. But since you have to do a mandatory 10, you have to do 6 years at medium or maximum status before you can be reduced to minimum. And in that, for certain programs and to participate in educational programs and different things like that, you have to be within 48 months to the parole board. When I first got to Eddyville, when you walk through the door, there is a sign that they take pride in, and it reads, "Beyond here, ye abandon all hope." And it's just a reminder that these harsh sentences, it's almost like this was designed to continue this prison and to sustain this prison industry and to have employment in certain areas that it wasn't at the expense of the majority of the minority and poor populations. So if any of you feel that a nonviolent offender should not be required to serve a mandatory 10-year sentence in prison before parole eligibility. That those sentences are too long, no one should receive that enhanced sentence. I ask you to please contact your legislators and speak to them about the jury empowerment and voice your concerns about the length of sentences for nonviolent offenders, because through all of this, it was stated that through the creation of these bills, it was to target the most serious offenders. But in reality, as the number has showed, it targets the lower end nonviolent offenders who are being punished worse than some of the most violent offenders. So thank you.
Thank you so much, Marcus. And I just wanted to say really quickly, we've had a few questions from panelists who are actually asking for more information and resources, which is fantastic. So I will be, we will be, Kentucky Policy, sending an email out to all the registrants with information that's relevant to today's session. So people will have that information coming to them. And thank you for everyone who is submitting questions. I'm going to go ahead and turn it over to our last panelist, and then we will have a continued Q&A afterwards. But I am going to introduce our last, but certainly not least, panelist for today, Jasmine Heiss. Jasmine, if you could come off of camera and wave, please. Jasmine is the program director at the VERA Institute of Justice, and she will be talking about the impact of sentencing on jail overcrowding. So, Jasmine, I'll turn it over to you.
Thank you, Carmen. And I should say at the top, you know, I deeply missed coming to Kentucky, and I'm always so humbled and inspired and grateful to be surrounded by brilliance and innovation and creativity by Kentuckians, particularly in the face of this system that is so harsh and cruel and dehumanizing. And I guess I am grateful in the midst of a pandemic for Zoom, which means I can still be part of those conversations even from afar, but I hope to see folks in person again soon. As Carmen said, my name's Jasmine Heiss, and I direct the In Our Backyards initiative at the VERA Institute of Justice. Now, in this capacity, I mostly focus on jails, and particularly small city and rural jails, and the role that they play as sort of the front door of mass incarceration and of this justice system. And to some people, right, that might suggest that a conversation about sentencing is a strange one to join. But as many of you know, in Kentucky, the jail and prison systems are almost inextricably bound up together because of the degree to which the Kentucky Department of Corrections relies on local jails to accommodate this increasing punishment and the continued rise of mass incarceration. Folks are housed in local jails in part to help keep the state prison system from catastrophic overcrowding, although it hasn't prevented, you know, as folks have noted, both jails and prisons from reaching really dangerous levels. So even after the sort of precipitous decline that was triggered by the spread of COVID-19 in the free world and behind bars, as of early January, there were more than 8,000 people sentenced to felonies who were being held in the state's local jails for the Department of Correction. And, you know, the justice reform movement we broadly are very familiar with and generally understand the perverse incentives that are created by the private prison industry, a privatized prison system. But the fact that very similar dynamics exist in public justice systems, with incarceration not necessarily generating profit for a company, but generating revenue for a county, that tends to get much less attention. So Kentucky's full service jails, as you may know, receive approximately $30 a day for every person that they house on behalf of the state prison system, people who are sentenced to low-level felonies. And many of the state's jailers or county judge executives will point to the fact that this is not enough money to adequately cover the local costs of incarceration, any programming that people might receive, that the state, you know, spends more than that per day on people who are in custody in a state prison system, and they're sort of devolving costs onto the county level at a cheaper rate. But at the same time, even with this concern that that money doesn't adequately cover incarceration, many of Kentucky's jails have been overbuilt with the sort of implicit or in some cases explicit intention of taking advantage of this revenue stream. There are beds that are added when they build bigger jails that are, set aside or sort of earmarked for people who are meant to be housed for the state. And one of the major consequences of this system, right, unsurprisingly then, is that when you begin to have a conversation about sentencing reform in Kentucky, and specifically about the defelonization of offenses, what is very obviously good policy, just policy, less racist policy, becomes mired not just in the usual politics of law and order or tough on crime, it also gets really caught up in a conversation about economic survival. And this is particularly true for smaller, poorer counties where the revenue coming in from the state to house people is meant to offset the cost of running their local jail or of locking up people who are detained pretrial because they're poor and they can't pay bail, or they can't pay their child support, or they can't pay fines and fees, or, as Marcus sort of has alluded to and others, they're caught in this giant net of supervision of the probation system and are locked up on probation violations. So, connecting this larger policy context to a current reform conversation, I think this becomes particularly clear in the context of proposed changes to Kentucky's felony theft threshold. Many of you know, certainly some of the folks on this call even better than I, this is a reform that policymakers have continued to come back to, have continued to try to pass, and found very challenging to move, in large part because of the anxiety of cash-strapped county leaders who, don't necessarily disagree with the substance of the policy, but are concerned about the economic consequences of reduced revenue. So if a person is sentenced to a misdemeanor instead of a felony for stealing something, right, it means that counties are on the hook suddenly for the total cost of that person's incarceration. So as many of you probably know, Kentucky's felony theft threshold is set at $500, where it's been since 2009. And this is precisely what has given rise to the very dynamic or the very situation that Marcus described, where if someone takes a phone, for example, suddenly they are on the hook. They could be charged and convicted of a felony offense. And not only will they have to serve a longer prison sentence, not only will they, potentially be at risk of falling under the persistent felony offender statute in Kentucky, they also have all of the collateral consequences of a felony conviction. Even if it's expungible, that will only come, if it does, after the period of incarceration, after likely a plea deal at which a prosecutor could hang that more severe sentence over someone's head, and likely, a fairly lengthy term of supervision. And then finally, maybe a person can have broader access to things like public benefits, to scholarships, to housing, if they can expunge that felony. So legislation has been introduced this session that would raise the threshold to $1,000. And as many folks have pointed out, this would bring Kentucky in line with surrounding states. Though I should say, this is not a transformative reform. This would not put Kentucky sort of at the front of the pack. I am coming to you live from the Commonwealth of Pennsylvania, where the felony theft threshold is $2,000. In deep red Texas, the felony theft threshold is $2,500. And this is a policy, even if it's incremental change, that makes sense for a lot of reasons. As has been underscored, our decades-long experiment, our racist, classist experiment with mass incarceration has made it incredibly clear that longer sentences and more severe punishment do not deter crime. They do not have a public safety return. There's also specific research around felony theft that makes this really clear as well. So 2018 now feels like ancient history, but a study published that year by our colleagues at Pew showed that states that had changed their felony theft threshold either saw no change in property crime or saw property crime decrease. So, this is possible. It will not have catastrophic consequences. In fact, it will likely make communities safer and healthier and stronger. I should also say, right, in as much as we recognize, as other panelists have pointed out, that the massive expansion of prison and jail populations in Kentucky is a legacy of a racist war on drugs, the obvious sort of next front or, next place of conversation about defelonization is around possession and drug-related offenses. And again, this is not just good policy because it will save money, because it will keep families intact. It is good public health policy. As both Carmen and Nicole underscored, right, the COVID-19 pandemic has underscored the degree to which you cannot take prisons and jails out of conversations about public health. But I think it's really important to remember that even when we are not in the midst of a global pandemic, incarceration has deadly consequences for many people. I'm sure we've all heard the horror stories of people cold detoxing behind bars in Kentucky's jails, of what happens when, incarceration is positioned as a first line response to mental health issues, to substance use issues. But we also see those consequences on the other side when people leave prison or jail and are in the free world again. People are overwhelmingly vulnerable to death in the few weeks after they are released from prisons and jails, often because there's not real continuity of care. They aren't connected to resources in the community that arguably they should have had access to on the front end. And then even on a larger scale, when we look at the data around incarceration rates and overdose mortality across the nation, a county's prison and jail incarceration rate is a greater determinant of the overdose rate than many other factors. The only greater determinant is the degree of economic decline in a community. And so in this context, right, trying to address the state's jail overcrowding, prison overcrowding, and really defelonize and lessen the severity of some of its offenses, one of the proposed changes that often comes up, or one of the things that county leaders will point to with this economic concern, is the fact that, perhaps the state should just either pay people more who are housed for felonies to offset the costs of this shift, or begin to reimburse counties also for people who are serving misdemeanor sentences that had previously been felonies. And, what we would say, I think many of us who look at, again, the unintended consequences of this system, what happens when you position revenue and tie it to increased incarceration, is that instead it's really time to break the reliance that counties have on dollars connected to locking up human beings, not just abstract numbers, as so many people have really importantly underscored. And for me, right, one of the places that becomes really clear, one of the things that illuminates, is how much you can't pull apart these conversations about pretrial justice, for example, and sentencing. I think, hats off to KSAP, to DPA, and others for, in moving this conversation forward, sort of underscoring, right, that incarcerating someone for a misdemeanor offense, both pre-trial and after they've been convicted, is not an inevitability. It's a policy choice. And so if there is concern about the economic impact of having fewer people convicted of felonies, the obvious place to look to reduce the consequences, the economic consequences of that impact, is A, not to detain the person before trial if they don't pose a very clear risk to public safety, and B, not to keep people in jail after they're convicted. Again, thinking about the dramatic decline in jail and prison populations that was sort of triggered by COVID-19, we nationally saw people suddenly realize, whether they were law enforcement, judges, probation officers, that perhaps in these extraordinary circumstances, incarceration didn't always need to be a first-line response. And this was true with the expansion of administrative release, people being automatically released for many felonies and misdemeanors, low-level felonies and misdemeanors before trial, but also, an expanded use of non-custodial sentences. And that ultimately, right, should look like people being held accountable in different ways, not just being shifted to this larger form of control like home or house arrest or electronic monitoring. And so I think, moving forward, really that is the challenge and the opportunity for Kentucky to say, what will it look like to rethink not only punishment, not only politics, but also what a just economy looks like and what it means for all people in Kentucky to be able to survive and thrive economically without relying on this fundamentally harmful system of mass incarceration.
Thank you so much. I know we have a couple of questions from the audience, different questions everywhere. So, and I even personally, I've learned so much today, and really want to dig in the time that we have left. So something I want to dig into that was mentioned throughout the presentation, and I may ask Jasmine, since she was the most recent speaker, but really I'd like to hear from anybody on this about, is that something that was mentioned kind of throughout the presentation, either directly or indirectly, was how punitive culture really fuels bad policy responses in sentencing, and gets us away from where we want to be in addressing those root causes that Jasmine especially was talking about. So I want to hear from you all. I'm curious, what strategies or tactics have you all found that has been helpful in addressing the culture of punishment that fuels these policies, either in Kentucky or even in other states? So Nicole, it might be great to hear from you too, since you do work in other states as well. But yeah, that's my first question for you all.
Thank you. And I just want to say that it's been enlightening to hear from everybody. I'm so sorry my camera cut off right in the middle of when I was answering that question. You know, my Wi-Fi is spotty. And so, and you know, but an opportunity around working from home is to join you all this morning. I'll say, I think one of the challenges is trying to create interactions between lawmakers and other folks trying to persuade, you know, with influence over the state sentencing policy with people directly impacted. One way is through the smart sentencing advocates at the ACLU led by Marcus and others. Another way is through interactions with people currently incarcerated, currently in prison. The challenge is scaling that out. You know, there's been a couple of national partners who have encouraged visit a prison efforts, you know, holding legislative hearings or legislative meetings with state lawmakers inside of prison walls so that there's dialogue with folks currently inside who can hear about the experiences that might have led to their imprisonment, hear about the work that they do day to day as they age out of crime while inside and are doing the personal work that we all should be doing and they are doing behind the walls to improve themselves. But the challenge is scaling that and making and sustaining those interactions, right? Because it's not just one-off. It's just not that one opportunity. It's probably over many interactions that people's worldview around the people who might be in prison, who might be even in prison for very serious offenses, despite the sentencing structures that Marcus and Damon and Jasmine provided an overview over, contribute to. I'll say that in this midst of working from home, perhaps there's an opportunity to engage directly and figure out a way to do virtual in-person meetings with people behind the walls and state lawmakers and the people in your audience today. You know, maybe the Kentucky Department of Corrections would be open to that, and those interactions can be virtual and not, you know, not in the same way that they would be if they were in person, but given that nobody is, you know, meeting in person right now, in the short term, it's an opportunity to at least try that.
I will, you know, I want to underscore, I think, something that Nicole and Marcus really laid out, that so often there is this enormous gap between the way a policy is written and the way that it is enacted onto people and onto people's bodies and onto their families. And I think making legislators cognizant of that by underscoring, right, this is what happens to a person, not a number, not a dollar sign in your budget when you choose to write this policy. I also, you know, to Nicole's point that this is a political problem and not just a policy problem, one of the things that our research and our work has shown really clearly, right, is that incarceration rates are high in every single American community. That, in fact, now they're the highest in rural communities and smaller cities. So, as I would say, the momentum of movements to hold policymakers accountable and to sort of illuminate different possibilities have taken root in bigger cities with the election of progressive prosecutors, with real deep engagement in legislators. That has not necessarily been the case in smaller places. And so having a strong voice to say this happens in your backyard to state legislators, you are harming your constituents and you have a responsibility to fix it. That is critical and important. I would also love to know, because Damon in many ways oversees the folks who are on the front lines of making these arguments to judges across the Commonwealth, anything that he has to say about sort of at that level, right, in the courts, trying to dismantle this this addiction to punishment.
Well, I mean, that is the huge challenge, of course, because so many people within the criminal justice system, including candidly within our own ranks, within the defender community, are just wired from the beginning that you respond to every situation with, well, we'll send them to jail, we'll threaten them with jail, we'll put them in jail, we'll arrest them, that is the societal response to anything we don't like. And that, of course, is how biases and discrimination gets in, because it's such a gut feeling that if I'm mad about something, I've got to pass a law to make prison as the option. And if I pass a law to make prison as the option and they still do it one more time, well, that means the sentence isn't long enough and we need to make that sentence longer. That's just the way so many people are wired. And local judges, one of the things that we've done as public defenders is try to implement social workers and alternative sentencing workers that take cases and they present alternatives to incarceration. And that's exactly what they're trying to battle, is just to open the window that there is another choice here. Prison's not the only option. Jail's not the only option. And some of the great statistics that your group, Jasmine, have put out, in Nicole with the Sentencing Project, that shows the negative impact on prison and jail, and trying to make the argument that if our goal is that the world will be safer in 5 years, not putting someone in jail may accomplish that goal better than putting them in jail. And a lot of people, it's just hard to get them to hear that. But I believe that data, and I believe that's true, and we're trying to make progress.
Thank you all so much. So another question we have that is especially relevant right now is, can you all share the specific bills we might help our constituents track and advocate for and against? And I know there was some mention of that too, but I think this is a great opportunity to go back to that and tell people what's going on right now with the legislature.
Yes, right now that House Bill 126 from Representative Massey, that's the felony threshold bill that Jasmine was talking about earlier. Senate Bill 36 from Senator Westerfield, that's the end of automatic transfer of juveniles to adult court. The importance of that is that if there's 4 juveniles in the car and there just so happens to be a weapon, all 4 of those individuals are automatically transferred to adult courts. The prosecutors, the judges do not have discretion over that, but they would like to. And this bill right here would actually give them the opportunity to do that. And then Jasmine also spoke about, what were the bill numbers again? House Bill 126, that's the felony threshold, and Senate Bill 36 is the end automatic transfer of juveniles to adult court. And then we have the Keys Bill, which is House Bill 25. And then the restoration of voting rights is very important, and that's House Bill 232.
And I'll chime in on the jury empowerment bill that I discussed. No version of that has yet been filed. We do believe a version will be filed, at least as the PFO, but there's no number to point to at this point. But there are, as I talked about, things that make the situation worse. There are a ton of bills that I won't go through them all that make those incremental worse changes to the statute. One that I'll point out that some members of this group have been involved in the past is to make criminal mischief, damage to property statute specifically apply to landlord-tenant disputes, that a landlord can bring criminal or can go to the county attorney to get criminal charges brought for damage to rental property. That's already the law. If someone intentionally damages property that doesn't belong to them, that's a crime already. Our belief is that, similar to other things I've talked about, this will lead to more cases simply because they can then point to this specific, and landlords can use a threatened prosecution to try to get back rent or deal with other circumstances in that landlord-tenant relationship through threatening this criminal statute. And we believe many cases will be brought, and the criminal courts will be used as a collection agency for landlords. And then, of course, when poor people don't pay and something's in criminal court, what happens? There's a probated sentence that's revoked and people go to jail or prison. That's going to play out if that bill passes. I believe that's Senate Bill 11. It's already through, I believe, the Senate. I know it got out of committee. I think maybe it passed on the floor. So, we haven't learned all our lessons yet.
The inimitable Shamika also mentioned in the chat another regressive bill, the protest-related bill, and I will just say, from my limited perch looking at states across the country, that is certainly part of a phenomenon that we're seeing in multiple places. I know of similar bills filed in Florida, in Tennessee, in Indiana. I'm sure Nicole knows of even more than I do. And I think, again, the sort of reactionary tendencies of policymakers sometimes to say there's a particular thing that made us angry, and so what we're going to do is pass sweeping legislation that creates new mandatory minimums that more harshly punishes people. The challenge that we all have, I think, constantly in these moments is thinking about how to make progress and bring transformative ideas to legislators while also constantly pushing back against things that are, very obviously meant to punish people who dare to challenge, in this case, right, racist police murders. So that's another one that I would say deserves folks' attention and energy. And thanks to Shamika for lifting it up.
So I think there's one more question. I think that is a great place to kind of wrap up, since we have a few more minutes. And that was the question about what a just economy means. And it was directed specifically at Jasmine, but I'd welcome any answers from any of the other panelists as well about what is a just economy and what would that look like for our communities and going forward as it relates to incarceration.
I'm going to be really brief and then pass to other people. I think, again, I don't live in Kentucky. I don't live in a rural Kentucky county. I live in Pennsylvania. And so it is not for me to say, right, what to people who live in that community, what their most ambitious vision of a just economy should look like. What I will say is some of the models that we've seen elsewhere are things like, and Nicole can speak to this, closing and repurposing carceral facilities, whether jails or prisons, into things that truly serve community needs, ideally with pretty significant transformation. So you're not just giving people, for example, treatment or resources in a space that still feels like a prison. But then also, right, some of the reinvestment efforts that are true community-driven reinvestment, to say, if we have cost savings from reduced incarceration, what does it look like to put directly impacted people, service providers, young people in the front seat of saying what their counties, what their communities actually need for things like crime prevention and justice.
Yeah, I agree. And in some of the follow-up materials I'll share with you, Carmen, there's some written up information about repurposing prisons. There's that's sort of a new conversation that's happening to the extent that folks can be having those discussions in Kentucky. think you will be leading this work nationally. And so I too would, love to learn how those conversations go in Kentucky, not just in the cities, but also in more rural areas as well. And I think that that can contribute to what a just economy might look like, particularly in the context of challenging mass incarceration and working to acknowledge the harms done by the high rate of incarceration, not just in Kentucky, but nationally.
Alrighty, well, we are right at noon. So I just want to say thank you to everyone who joined us today, and a special thank you to all the panelists for being here as well. We really appreciate your time and expertise on this really important subject and this conversation, which is sure to continue. So thank you all very much. And just as a reminder for everyone out there, again, we have our final session next week. Don't forget to sign up. Economic security in the age of COVID-19. So that'll be next Friday on January 29th. So go to our website, kypolicy.org/registration, and be sure to join us there. So again, thanks to everyone, and I hope you all have a great weekend.
Thank you, Carmen.
Thank you.
Thank you all. Thank you, Carmen.
Thanks, Carmen.
Bye, guys.